Well, thank you to everyone who is joining us tonight. We really appreciate the huge amount of support that has been shown on this issue. And I want to, you're the reason why we're here. Everyone who's on this call, you are the reason why we are here and why Attorney General Derek Brown is here. And we are just so grateful to be able to have this conversation with him and to be able to talk about the lawsuit that is frightening everybody. I'm going to go ahead and share my screen. So we are talking about the Texas v. Becerra lawsuit today that threatens Section 504 civil rights. And in our conversation today, we are grateful that Derek Brown, Utah Attorney General, is here with us to discuss Utah's involvement with the case. We have Utah Parent Center representative, and we have Joey Hanna, who is executive director of the Utah Parent Center, and we have Nate Krippus, who is the excuse me, I'll get your title here. Public Affairs Supervising Attorney with the Disability Law Center. And so we're grateful for them to be here in attendance. My name is Francesca Rose. I am president of the Utah Food Allergy Network. And we are a nonprofit in Utah that works to educate, advocate, support, and raise awareness of the severity of life-threatening food allergies. And we support an estimated 314,000 people in Utah with food allergies, and the numbers keep growing every year. So disabilities come in all shapes and sizes, and food allergies are one of them. And so I'm grateful to be here with my colleagues in the nonprofit world and with Attorney General Brown to be able to discuss this important topic with us. Our agenda tonight, I will give a very brief overview of Section 504. I will talk about the timeline leading up to the Texas v. Becerra case and initial concerns with the case. And then there were some updates to the case made yesterday, which is awesome that we have Attorney General Brown here to discuss those updates with us. That's joint status report. And then we're going to get right to the questions and just a deep discussion on what it all means, because we've had a lot of great questions and then possible next steps. So really quickly, Section 504 is one of my favorite, absolute favorite laws, disability accessibility laws, and I could talk about it all night, but I'm not going to talk about it all night. It is in the chat, we are going to be sharing with you some helpful links to understand Section 504. If you are unable to access those links, my contact information will be at the end of this, and you can email me and I will send you links that we share tonight. But Section 504 of the Rehabilitation Act of 1973 is a national law that protects qualified individuals from discrimination based on their disability. The non-discrimination requirements of the law apply to basically to anybody who um, basically anyone who receives financial assistance from the federal government has to comply with this rule of non-discrimination. It forbids organizations and employers from excluding individuals with disabilities, gives them equal opportunity to receive programs and services. It defines the rights of individuals to participate. So let's talk about what those rights are. Who is protected from discrimination? So Section 504 specifically lists what it means to have a disability. They say qualified individuals with disabilities are persons with physical or mental impairment which substantially limits one or more major life activities. And it's also people who have a history of or who are regarded as having this physical or mental impairment that substantially limits one or more major life activities. So what are the major life activities that 504 includes? Caring for oneself, walking, seeing, hearing, speaking, breathing, working, performing manual labor, learning. So in the food allergy world, I've been in the food allergy world for 22 years almost, and And so people with food allergies, we can use 504 plans in public schools because if our child is suffering from anaphylaxis due to their allergen, their breathing is affected. And so you see breathing is on that list, and that's an important thing to note that it keeps our kids alive, basically. We love Section 504 as food allergy people. So it also states that if you're receiving services like education or training, you have to meet the normal and essential eligibility requirements. You have to be able to do the job that you were, and for like employment, uh, you have to be able to do the essential functions of the job you've applied for and hired for, and that they have to give you reasonable accommodation. So a reasonable accommodation means an employer is required to take reasonable steps to accommodate your disability without it causing undue hardship, like, putting them out of business or something. So that's an important thing to note. So just a really quick summary. It's a civil rights law that prohibits discrimination based on your disability in any activity, in any entity that is receiving federal financial assistance, which is important because, we don't want second-class citizens. Everyone who is a citizen should have equal access to what our tax money is being spent on. It mandates accessibility in public schools, colleges, workplaces, any federally funded programs. It ensures equal access to education, employment, and other services. It applies to various entities, including schools, hospitals, social services, nursing homes, you name it. It's a workhorse of a law. And it's just wonderful that we've had this for 50 years, 50 plus years. It requires organizations to provide reasonable accommodations for participation of individuals with disabilities. So this is a really, really important law that we don't want to lose. It's important. So what is super interesting leading up to having this lawsuit, and I think is important to note, is this timeline. I'm going to walk you through this timeline. So Section 504 was enacted as part of the Rehabilitation Act in 1973. And I want you to notice the timeline here. In 1977, the U.S. Department of Health, Education, and Welfare they issued enforcement regulations. That's quite a few years from when it's enacted to when they're actually issuing enforcement regulations. And I think that's important to remember with the discussion that we're going to have coming up. And in 1978 to 1980, there are legal challenges that refine the implementation and scope of Section 504. That is also important because our laws the way our country is set up, we can enact a law, but then there can be pushback, and that's an important part of refining and polishing the final product, is having input like we've been having today and this week, and so with the Attorney General, and having that input that refines the law. Then you've got in 1990, the Americans with Disabilities Act, ADA, was signed into law. 1991, they published regulations that guide the enforcement of that. In 2008, they did the ADA Amendments Act. And if you say it, Americans with Disabilities Act Amendments Act is quite a mouthful, but it broadened the definition of the ADA. And then in 2024, we have the Department of Health and Human Services finalized a rule to enhance protections under Section 504 on May 1st last year. Now, leading up to this process in 2023, the fall of 2023, they had open public comment set time, and thousands of health people, disability, you name it, people could comment about what they thought was important to update in Section 504. And this finalized rule that came about, they took all of those comments and then analyzed them and decided okay, this is a good one to deal with. We're not going to deal with that. And it's really interesting to read. You can go read what they decided on, what they didn't decide on, and why. They give comments on that. So it's really a fascinating read. Some of the updates in this rule are super important because, like, for instance, communication has changed a lot since 1973. And so making sure that communication accessibility for people with disabilities is updated, that's an important rule to have. And so there's a lot of updates that are good in there. One of the updates in there was to uh well, we'll talk about that. But when we're talking about the lawsuit, uh and they talk about the final rule, that's what they're talking about is these 2024 updates that were put in place on May 1st last year of 2024. All right. Um so in the original lawsuit, Texas v. Becerra, you can read through all of it. There's a lot of stuff in there, 46 pages worth of good stuff. And on page 42, you have what is called the demand for relief. And this is basically what the plaintiffs are asking the court to give them relief of, okay? Plaintiffs in this case are the states, the 17 states that are signed on. Now, it's important to note that even if one state drops out and only 10 stay on or 5 drop out, whatever, it's what they're asking here affects all of us. And so having a place at the table for negotiation, I think is really important to remember here. So basically, if you look at what the lawsuit is asking, they're asking the court for like 7 things here. The first 3, A, B, C, have to do with the final rule. They're asking them to uh, stop from enforcing the final rule. So enjoining means to stop, basically. Um, to declare the final rule, that it violates the Administrative Procedure Act, and to hold unlawful and set aside or vacate the final rule. They want to just stop having to enforce that final rule, those 2024 updates that happened, and that it's unlawful. And then the last 2, F and G, talk are just typical things for lawsuits, award attorney's fees and, whatever. If the court wants to give us more stuff, that's great. But D and E of this demand for relief is what is causing a huge uproar because it kind of feels like, oh, they're throwing the baby out with the bathwater. Why can't, if you don't like stuff in the final rule, then let's talk about just the final rule. Why are we declaring, in D it says declare Section 504 unconstitutional, and E says issue permanent injunctive relief against defendants, enjoining them from enforcing Section 504. So if you remember again, enjoining means to stop from enforcing that. So this is very scary to the disability community because we rely a lot on Section 504 in our daily lives, multiple times in our daily lives. So this is very, very scary. Now, uh, this is this is where we're going to hop into a discussion with our Utah Attorney General Derek Brown, and we've got Nate Krippis from the Disability Law Center, and me, and we have everyone's questions that were submitted. I just want to thank everyone for your questions because it helps to help refine the process, and it helps our our people who are fighting for our rights, Attorney General here, Derek Brown, to know what's important and how to approach that negotiation table. So your voices matter, and we're going to discuss the involvement in the case, details about that, and also um, talk about the update that happened yesterday, the joint resolution update to the case, because there are some questions about that as well. And we want people to understand the process. There's been a lot of questions about the process and understand what it all means. And so I'm going to turn the time over to Derek Brown, Attorney General, for a minute and let him talk. And uh, Nate Cripps and I will probably pop in with questions here and there. And I've got a list of everyone's questions, and we'll try to make sure that all of them get covered. So, Attorney General, you've got the floor.
Fantastic. I appreciate that. And thank you, Francesca. That's a great introduction, sort of outlining the importance of 504. There's so many of us rely on the protections in 504, including myself. I mean, this is, as I've mentioned, I know a number of you have probably heard, this is also personal for me and for my family. And so this is a law that we've relied on. And it means a lot to us. And I appreciate those who are advocating. I actually ran into Nate earlier today up at the Capitol, who's up there with the Disability Law Center, always advocating up there and doing a great job working with legislators. A couple of quick things. First of all, I was just looking, Francesca, at the number of participants. This is fantastic. Thank you. I mean, this shows the interest in this. And it's kind of funny because I mentioned that I was going to be on this call today to someone at the Capitol, and they said, well, why are you doing that? You weren't even the Attorney General when this whole thing happened. Are you going to hop on and you're going to get beaten up for something you didn't do? And I said, that's this is the point of being an elected official. The feedback is incredibly important. And so, Francesca, you mentioned the kind of the refinement process. And so if I can just take 4 or 5 minutes and walk through where we are, why this is important, and kind of where I think things are going. I want to start by just making really clear that to me and my family, 504 is incredibly important. I mean, granted, it was passed 52 years ago, but we continue to rely on it in our schools, for our kids, the protections in, under IDEA. And I mean, a lot of you, like my family, probably have IEPs that are incredibly important. A lot of those protections are wrapped in to that as well. And so as Attorney General, this was a lawsuit that was filed last September, and there were 17 states that joined the lawsuit. Funny enough, I was not aware of this. As the new Attorney General, there are a lot of things as we're working through. We have a new team. We've got a fantastic team of people that understand a lot of these issues. And it wasn't until last Wednesday that I had a number of people that I know text me. And they said, hey, tell us what's going on with 504. Like, we know that this matters to you. What's Utah doing in this lawsuit? And so I said, well, I'm not entirely certain. I mean, I'm not the one that joined the lawsuit, but let me look into this. So I looked into this and started getting information about this. And understandably, there are some concerns. First of all, just so that everyone knows, the underlying lawsuit deals with, if you go back to that timeline that Francesca showed us, the regulation with Health and Human Services from last year became public. This lawsuit, as I understand it, was filed not long after, and it was specifically dealing with a regulation. And I've had a lot of people that have asked me, so what's the point of the regulation? And I said, well, or the point of the lawsuit really is a battle over who it is that gets to determine the meaning of these words and add disabilities into that process. I mean, who is it? The executive branch? Is it Congress? And so that's really what the lawsuit is about, is that battle back and forth. Who has the authority to do that? So fast forward to last Wednesday, I'm looking into this, and I said, look, I think this is a legitimate legal issue. And I had some people that pointed me to the very thing, Francesca, that you identified, is those claims for relief. And they do seem like they would be cause for concern. And it seemed hard to believe that the attorneys general would be trying to get the entire Section 504 invalidated. That just seemed, beyond like what I would have thought would be happening. And it seemed hard to believe. And so we started looking around. And just so you know, a lot of the feedback that we got was very welcome. One of the things I did when I ran for attorney general is make it clear the transparency and connectivity were going to be incredibly important. I mean, that's why I'm here right now, is I want you to know this matters, and I'm open for feedback. I'm open for information. If there's something that we're not doing or there's something we're missing. In fact, Nate and I earlier today talked about some interesting ideas, and I'm open to that. But let me just tell you what's happened since that point in time. when I realized that this was potentially problematic, what I did is I reached out to our other attorneys general. There's 17 of them that signed onto this lawsuit last September. And so I wanted to figure out where we were with this lawsuit. And we spent the weekend coordinating, communicating, and effectively saying, hey, does anyone here actually think that the point of the lawsuit is to invalidate Section 504? I mean, like I said, look, I am 100% supportive of 504. And everyone else basically said the same thing. And so what we did is we worked over the weekend to figure out what is the fastest way that we can come up with some sort of legal procedure that can let people know that as states, we are very interested in protecting 504 and protecting our kids. I mean, this is an incredibly important section of the law that we need to protect. And ultimately, what we've done is the quickest thing that we can do. And just so you know, lawsuits tend to be really slow, like painfully, obnoxiously slow, as many of you know. And the systems tend to work slowly. And so when you're advocating for kids, I mean, just the systems tend to be cumbersome and slow. And so what we decided was the couple of things. First of all, the most important thing we could do in this lawsuit is to identify how to protect 504. So what we did as a group was file what's called a joint status report. And we did this last night. And the language of it is pretty clear. We wanted to let the court know that the point was not to try and invalidate Section 504. And so here's the language. Actually, I wish I could. Well, let me just read you what it is that the actual language says. It says, and this is what was filed with the court. And so hopefully this is helpful. Oh, have you got it? Oh, great. Can you?
I have some screenshots
Boom. Oh,
there.
I love it. Thank you. And you'll see that this was filed last night. And so it says plaintiffs clarify they have never moved and do not plan to move the court to declare or enjoin Section 504 of the Rehabilitation Act as unconstitutional on its face. And one of the reasons, by the way, and if you could leave that up, Francesca, for a moment, one of the reasons I think that, and granted, I'm speculating because this is something that happened before I took office, but I think one of the reasons a lot of the other states may have been okay or just looked past that claim for relief is that it dealt with the concern over spending. And the concern was ultimately if Utah was in compliance with their state law, with our state law, but in out of compliance with the federal law, then that would jeopardize federal funding for our kids and for a lot of other programs. And so that's why they also included that second phrase, plaintiffs have not sought and do not seek to enjoin the disbursement of funds from the department on the basis that the statute is unconstitutional. And so there's a couple reasons why we did this. The first is that anything we do at this point in time, we need the judge to approve because this is filed last September. But this is something we didn't. We worked together with the administration and the 17 states, and we came up with this language that basically says, look, the point of the lawsuit is not to invalidate Section 504. So the hope is to provide assurity and comfort to parents that that's not what's going on. And so, yeah, Francesca.
So when I read that, and so I want clarification because when I read that, I think, okay, so you didn't want to declare it as unconstitutional on its face or on the basis that the statute's unconstitutional. Well, what are you declaring it unconstitutional? What reason? Is it the spending clause? Is it, like, because I feel like I feel like it still wants to declare it unconstitutional, and so not being an attorney, can you clarify that for me?
And I think, and granted, because I wasn't part of the initial process, I don't know the thought behind it. I think what was going on is that they were looking at, you mentioned the spending clause, and the concern really was, would we as a state lose federal funding if we didn't comply with the administration's new regulation? And as you mentioned, Francesca, it's kind of an ongoing process of refinement with these things. But at the same time, I mean, it's important that we know, that we know what we're dealing with. And one of the things that probably the most common question I got, and by the way, I had a lot of people reach out, and I see you smiling, Francesca. I mean, really, there were a lot of people that reached out, and this is great. I mean, the reality is that kind of input and engagement. I mean, I love that because what it does is it shows that people matter and they care about this. And frankly, that's something that I talked about when I was in conversations with others on this issue. So I said, look, this really matters to the number of Utah parents that have reached out. And so I appreciate that sort of engagement. Probably the single most common question that I got, and I'll bet there are a lot on this call asking this very question. That was, well, why don't you just withdraw from the lawsuit? Right? I mean, Francesca, did you hear that quite a bit?
I heard that a lot, but I want you to be at the table advocating for us. So I'm glad that you are still in the lawsuit so that you can advocate for us.
Well, and that's the reality of it is, and I appreciate that viewpoint because that's why we're still here. That might have been the politically advantageous thing to do or the easiest thing to do, but what an attorney does, an attorney general, a parent, someone who wants to solve this problem, is you want to stay there and you want to fix this. And I mean, think of it like a table with 17 seats at it. Every state who signed this last September has a seat at the table. And I know there's a lot of people who have said, well, why don't you just kind of, just leave the lawsuit? Not going to do that. I'm staying in it because I want to advocate on behalf of the kids in Utah. I want to make sure that whatever takes place is something that benefits and protects all of us.
Well, and if you leave, it doesn't matter because I mean, if you left, there's still 15, 16 other states there, and the lawsuit is still going forward. And but what happens is you don't have a seat at the table, and it still affects us. What is decided by this lawsuit affects all of us, whether you're at the table or not. And
And
so,
that's, yes,
is that
that-
right? Do we understand
that's,
that correctly?
yes, and that's exactly why I stayed, even though I had a lot of people reach out and say, well, the easiest thing is just to up and leave. Not going to do that, and sorry to disappoint people, but my job is to fix this problem. I may not have been around when we signed on to the lawsuit, but I'm going to be here and figure out how we fix this thing when all is said and done. And so the way I can best do that is to stay at the table and continue to work with other states to make sure that we are protected. In fact, that's one of the things. I mean, there's still things going on with this case because we are looking at ways to resolve it entirely. I mean, that's really where we want to go with this. One of the things, though, that we've done with this joint status report is basically say, look, as parties, as states and as the federal government, we're all agreeing that the point is not to declare this section of the code unconstitutional. And the reason we're doing that is because if for some reason that started to become, I mean, we haven't had a hearing on this really such that this has been argued with a judge, but if that ever were to come up, the judge would say, hey, you already agreed that that's not part of the lawsuit. So let's move on to the underlying case. And so that's the hope. And frankly, that's why I feel very comfortable in saying that our job was to protect kids. And I will continue to do that. And I feel good about the fact that we are where we are. I know people would love it to move faster. I would love it to move faster. When you have people beating down your door saying, you gotta do something, you'd love to be able to just do something overnight, but the legal process, I mean, we jokingly say that we may be good, but we're slow. And that's kind of the joke is it is very, very slow. But at the same time, it's a thorough process. And when the time comes that we have a resolution, I think that people on this call and those who have kids with disabilities and those who have the benefits of Section 504 protections will be very happy with the results. So I just don't believe that we need to be too concerned, but we need to be vigilant. We need to be aware. And Francesca, that's why we are where we are. That's why I spent the weekend working with other attorneys. And I'd love to move the process faster, but I think we're going as fast as we can when you consider that there are 17 states and the federal government that are all working on the same issue.
Well, and I brought back the timeline here because that's why I pointed that out before. It was enacted in 1973, and then 1977 they have enforcement regulations, they have legal challenges. Like for a decade there or more, they're discussing it, they're pushing up against it, they're refining it, and it's a refinement process. Um, if you watch some of the videos of that time period, the disabled community actually staged a sit-in in the federal building in San Francisco for 25 days. They didn't leave. And so these are hard fought rights, but as a so it is a slow process. And I think that people should realize it's a slow process. However, we need to be aware of what the process is. So as we move through this joint status report, um, okay, as a mom who has advocated for disability and children, I'm skeptical. I'm skeptical when I read this. I'm like, I don't know. I feel like you're trying to take away the accountability of the law by saying, "Oh, we're going to go ahead and give federal money to you whether you comply or not." Because in my experience, even with 504 plans and the best people, the nicest, most empathetic people in the world, sometimes they don't follow it, and it puts children at risk, it puts people at risk. And so if you say that it's unconstitutional due to, the it doesn't follow like the spending clause or whatever, um how do you help maintain the teeth, if you will, of the accountability part of following this law? Because I know reading the lawsuit, a lot of the states are like, it's going to cost us so much money. Well, yeah, but it's money that's meant to be spent on people, that everybody, and so what are you going to do to ensure that like what can you do to ensure that the teeth are still there for
Well,
the law?
there are currently teeth in the law, which is a good thing. We want to keep them there, and I appreciate you bringing that up because that's obviously, it's unfortunate that we need to sometimes mandate things like, treating people equally, and we need to mandate things like, making reasonable accommodations for disabilities. But we do, and I think that we've come a long way since 1973, and then as you mentioned in 1990 with the ADA, and we have laws like IDEA, which are also critical and have a lot of those same protections. But the law will still be in place, and so I think that the teeth in the law will remain. And the idea of those two sentences that you read in the status report were to say that whether you're looking at it on its face or under the spending clause, under either one of those, we want to make sure that Section 504 remains relevant, that it remains active, and that it's not touched when it comes to this lawsuit. And so there's a lot of support for that. I mean, that's the thing that I hope that people take away is that this was not necessarily a difficult conversation with other state attorneys general, because when we discussed this issue, everyone was on board. I think ultimately what's going to happen, and just, I'm going to just get on my crystal ball here, and you never know, because as you mentioned, Francesca, the legal process is very slow. But the fact that we've gotten as far as we have, as quickly as we have, and I've seen a lot of other things that are moving forward, and I can't discuss those yet because those are still works in progress. But I believe that we'll have a resolution fairly quickly that will give people here comfort to know that that 504 will be just fine. But I think the most important thing is just to give everyone some comfort that this is not an issue that I think we need to worry about, because we've, all the different plaintiffs have basically said, look, the concern you have that we're trying to invalidate the law is actually not a concern you need to worry about. And so it goes back to the underlying lawsuit. And so I think that's the reality is I'm staying there at the table. We've addressed this issue. There's an underlying lawsuit, which frankly, I believe will probably be resolved fairly quickly. But don't hold me to that because I don't know. Again, it's the legal process. The difference is with the legal system itself right now, because this case was filed 5 months ago, anything we do needs to have a judge's signature on it that's official. And this status report wasn't something that required a judge's signature. But what it did do is signal to everyone the intent of the 17 states. And so hopefully that's helpful. And I recognize it's at this point, it's not perfect. I think we'll have, more good news in the weeks to come ahead. And, and just so you know, I'm open for feedback. I mean, the reality is I'd love to say as the elected official, I'm going to get this thing right 100% of the time. But we're not always going to do that. And if we make a mistake or we do things that don't add up or something's wrong, I'm going to take ownership for that. And I've got a large team. We have 290 attorneys in our office. We're involved in thousands of different legal issues at any given moment. And so my job is to make sure that we do the best we can. If we make a mistake, we back up, we correct, and we move forward. And so just so you know, I'm open to feedback and I'm open to, not just on this issue, but in the future, whether it's food allergies or disability law center or any of the other groups that are part of this conversation, please, don't hesitate to reach out.
If I may add just something to your question, Francesca, about what the teeth will remain. I think there are a couple of things I would add to that. One is, this isn't the first set of regulations that have come out about Section 504 in the 52 years. So it's not as though there's just a law and then this was the first time we ever updated it or passed any regulations. There have been regulations passed for the many decades we've had it. So I think there's a lot of clear. There's also courts have make decisions based upon Section 504, and there's a lot of case law out there that kind of support some of these things. So there's a great deal out there that I think support. I think to the Attorney General's point about the law will still exist, and ultimately there's a lot out there that will do that. The other is, and this is something I would encourage. I know the AG is having discussions with the administration and things of that nature, and ultimately I know there are concerns with pieces of this final rule. My hope is that there are not concerns with all of the final. And we have a new administration, and as is their right as the executive branch, they get to pass new regulations, and some of that will be probably rolling back things from the previous administration, passing new things to kind of undo or change what the previous administration did. My hope would be part of those discussions is at a minimum, including some of these you talk about. There are accessibility things in healthcare that are included in this final. There are pieces of this final rule that I hope, and based on what the Attorney General said, I think he agrees with a lot of these things being important. My hope is those discussions will be about like trying to fix at least as little as possible of this final rule and kind of passing out what is going to give it some of those teeth that I think we all want to see it have. So I would just say I hope that can be a part of the discussion moving forward.
And can I add, I think that's a good point. I mean, so much of the focus has been on that one very small piece of the large regulation. And as Nate mentioned, there are a lot of different changes and updates. And I think things in there that are very, they're helpful. I think they will help our kids. And so I think that's a good point. So, I will keep that in mind as we have these discussions to make sure that it's not just undoing the regulation in its entirety, but, identifying if it's just this one piece or if there are other pieces, because that's just for better or for worse, that's the system we have, is that whenever you have an administration that changes, things sort of go back and forth, and it's hard. And I will freely admit it's hard to have that kind of whiplash. It's hard for companies. It's hard for institutions. I've done a lot of work the last month or two with the legislature, because there's a lot of bills up at the legislature, and Nate knows all too well a lot of the bills that are up there, and and it's a moving target, and you wish it were an easier process, but it is what we have, and so those are things that we'll keep in mind, and I appreciate that, because that's ultimately what we need to do in terms of protecting our kids and making sure that 504 remains intact.
Well, I appreciate this discussion. So I've had questions about what does the February 25th deadline mean for the lawsuit? What is supposed to happen by then? And what more can Utah do to prevent negative repercussions to Section 504 and the protections for Utahns with disabilities? What is the February 25th
I think
date?
that was the filing of when we were going to be filing a joint status report and updating the court as to where things were. And so this is just an early one that we're doing. And we're only doing this one right now with this language because, frankly, because of all of you. We want you to know that we're aware of the issue. We want you to know that this is something that needs to be addressed, and that you know, the fact that we've had so many people reach out, it matters. And so anyway, that's, you know, we will do that, but there are other discussions going on. And so I will keep this information in mind, including what Nate just mentioned in terms of the entire regulation and you know, perhaps making sure that we identify, you know, the things that are helpful as part of the overall package and not sort of throw out the proverbial baby with the bathwater, right? I mean, there are things that we need to do to keep it, you know, keep it moving. And there are reasons that we update these regs over time. I mean, the world has changed, the science has changed since 1973, and I think that's, you know, helpful recognition.
Well, I'm glad you bring that up because, well, first of all, in this update, it says you guys are going to file these update joint status reports every 21st of each month. So that's cool. There will be regular updates. But a question about, you bring up the science. So with these 2024 updates, there there was a lot of input from medical professionals and the public and disability people and groups. And so how much of that do you look at when you are deciding, oh, this is an important part of the final rule that we want to keep? How much of that science are you looking at to actually guide your choices? A lot of people have talked about how the American pediatric and psychological groups have updated their mental diagnosis things, and that's why a lot of the brouhaha is happening right now, if you will, because of the term gender dysphoria. That there was a court case in the fourth district court, I believe, recently, sometime in the last few years, that said gender dysphoria might or may, I think the term was may be eligible to be a qualified disability under 504. And so because of these different updates, they looked at the science and they looked at that and they said, yeah, let's update it. But how much of that are you guys looking at? You know, all of these 100,000 of medical professionals that commented, how much of that do you look at?
Well, and that's really not something that, as the attorneys, what we're looking at is the underlying case, which deals with really at this point one issue. And if you kind of go through, there's a lot of science and stuff talked about in the brief, but the reality is there's really one issue. And for some people, this may be a really boring issue. For an attorney like me, I really am interested in it. And that is like we need to make, I mean, these are important decisions and they have real impact on real people. And we need to take those decisions seriously. The question is, who's the decision maker? And right now, the ultimate question is, should it be the executive branch that makes this decision, or should it be Congress who passes the laws? And that's ultimately what this case is about. I mean, when I've had people that have said, so what's the real, you know, like really, what's this about? I've said, this is kind of, I mean, as I read it, and I wasn't there obviously when it was filed, but as I read it, the way I view this is it's kind of, it's an ongoing, you know, continuation of a battle that we see right now all over the country, particularly with the new administration. And also we saw this under the previous administration as well. And that is when it comes to regulations that may overreach, can they do that? Or is it really Congress that makes the decision? And so that's ultimately what it comes down to. And I think, you know, I think when push comes to shove, the lawsuit will likely be settled in some way with the Trump administration. That's my guess. I don't know at this point. But that's really what, so for the attorneys, it's less about, okay, what, you know, are we looking at the most updated science or where, you know, DSM, you know, identifies it or whatever. I mean, for us, it's really that legal question of who has authority to make that decision. And there are hundreds of lawsuits all over the country really identifying that one issue. But, you know, this is one on a very specific, narrow issue. There's a lot of other lawsuits on very different areas involving everything from, you know, education to here in Utah, you know, federal lands is a big issue. And the question is who gets to determine who controls those? Is it the agency or is it, you know, to what extent can the agency make the decisions? that may be federal lands, but it's the same legal issue that's getting litigated all over the place. And so anyway, sorry to like get into sort of the geeky lawyer stuff, Francesca, but that's really what
I
it
love
is we're trying to work through, who is it that gets to make the decision? And that's really what is at the core of this lawsuit.
If I can
right.
add just a little bit to the lawyer geeky stuff, if that's all right. To your point, Attorney General, I will just add. I think you're right. It's a question of, is it Congress, is it the executive? I think we also is it the courts, right? I think is the others, are they're going to decide a lot of this too, ultimately, right? But to your earlier question, Francesca, I will just say I think, for me, I think this is where the rulemaking process, and I will not get geeky lawyer enough to talk through the entire administrative rulemaking process because nobody wants me to do that. But that is where those comments come into play with, when this rule was promulgated by the previous administration, they obviously went through and there was a lot of feedback from everyone. We provided feedback from the DLC kind of on our perspective as one of the disability rights organizations. So I think a lot of that is out there. My hope is that, when the new administration is looking at what they can do to address the concerns from these 17 states and make changes to this rule, whatever that looks like as part of this, that they will look back at those comments and review those and address that. But I understand that's not going to be the position of the attorney generals, but it's something I certainly hope the administration will take a look at, because I think there was a lot of good feedback provided to them when the last administration put out the rule. So
Well,
Right.
yeah, and I appreciate that you were part of that process, because the reality is a lot of times I've served in the Utah House of Representatives, and one of the most frustrating things for me is that we would pass legislation and it would affect real human beings, but generally the people who were most affected by what we were doing weren't there to talk about how it would affect them. And so, that's why a group like the Disability Law Center can be really helpful, because like you said, you were able to chime in and say, hey, you may want to consider, we're on the ground working with people on a daily basis, and what you're proposing either, may sound good, but in practice, it actually may not work out. And I saw that all the time as a legislator. I can't tell you how many times we'd come back in a subsequent session and we'd be working on the same issue because we realized that we passed a bill that just didn't work, to put it bluntly, and I'd love to say we always get it right, everyone, but the reality is we don't. We're human as well, and I'm going to make mistakes as the Attorney General, and I hope that I know that we have a political process and a political environment that is prone to, chew you up and spit you out if you dare to admit that you don't know everything or that you made a mistake. But, I'm willing to do it and hope that, let the chips fall where they may. So,
Well, I, for one, am super grateful for you showing your dedication to transparency by being here, talking about it, admitting and what the process is. So speaking of the process, one of the questions that came in is, what is the process going forward with this lawsuit? What happens next, and when and how will we know that this is resolved? Because as disability community advocates, we will be watching this. We know it's a long haul, and what's the process?
well, there's two things. First of all, there's the regular process of what would take place in the lawsuit, just as a matter of course, where you have motions going back and forth and, discovery and that sort of thing. But I am convinced that with 17 state attorneys general very committed to resolving this issue, we're going to get some resolution soon. And the minute that happens, what we will do is we will send that to you, Francesca, Nate, and Tyler, and Carrie. We'll send you that information as soon as it happens. Like we did. We filed this last night, and by this morning, everyone had a copy of it, of the status report, and so everyone knew about it. And I think I did 7 different media interviews today, trying to explain what it means, what we're going to be doing moving forward. And so we will keep you apprised of what happens, and I hope that it will move quickly, and we'll do everything we can to move it quickly.
So there's been a lot of concern there were many questions concerning about what happens if the Department of Education is demolished, as has been threatened, and what does that mean like, is there a plan for our state to help cover and shoulder the responsibility of taking care of public education and disability services for, because some of these resources for disability come through the Department of Education. And I've had school nurses talk to me, and lots of different people talk to me about that. So can you, and
If I had a
guess,
crystal
pull out
ball,
your crystal ball again, because we all want one. And
I wish I wish I knew. I mean, it's so funny how I have people all the time that will see something that's being done in Washington at the moment and have a lot of concerns with like an executive order or something. And then, they'll say, well, what do we do? And I'll say, well, why don't we wait 24 hours? Because it's likely to change in 24 hours. And one of the things I do, just so that you know, I mean, a lot of people don't know what the Attorney General does. Like I said, we have almost 600 people in our office, 290 attorneys, and we do everything from advising state agencies to criminal prosecutions. I mean, we're sort of the state's law firm, and and we literally are involved in every conceivable legal issue that you can imagine, from Medicaid to education to Section 504. I mean, you name it, we're involved in it. And the reason I bring it up is because there are always concerns. I mean, right now we're hearing about funding being cut from NIH funding. So I've had a lot of phone calls on that. And as these executive orders change things, we're the ones that get the phone calls and say, okay, what does the state agency do? How do we comply with this new executive order? And it's not always cut and dry. And so we're doing the best we can in a very fluid environment. But ultimately, we'll keep you posted on where things go. As far as the Department of Education, I really don't know where that's going to go. I mean, I've heard different things in terms of what things will look like, and I just don't know. I mean, one of the concerns though that we've had specifically when I looked at this lawsuit and a lot of the concerns raised by people, I'm sure on this Zoom right now, was what if we lost, federal funding based on noncompliance with the updated regulations? So it's always a concern. And there are so many federal funds that come into the state. Our state budget's about $30 billion a year, but there's a lot more money that comes in through federal channels. And so we don't want to risk those. And I mean, the hope is if something happened to education, they would just block out the funds to the states. But I really don't know. If I had a better sense of that, then I would, be a news commentator or something like that. But I just, we'll see. It's a moving target.
okay.
And I will just say, Francesca, this is something that I know we have promised that, all of the changes and the impacts to the disability community is something that my colleagues and I will be watching at the Disability Law Center. We are, right now it's the legislative session, as the Attorney General mentioned, so we're a little bit tied up with what's happening at the state level, but there likely will be a lot of changes at the federal level, and something we have committed to doing is trying to, through our website, we do some regular videos, folks on our staff, and try to get out information as quickly as possible. It's something we'll try to help people understand what's happening to the best of our ability, to really keep people informed. Is something we're going to try to do over the next, however long, these changes are coming up. So.
Well, I appreciate those reassurances. It still feels a little unsettling. I'll have to admit, I don't feel settled, but we'll try to be okay with it. Just two more questions. Do you have time for two more questions
I do.
that I feel like haven't been covered? One person writes in and says that in the lawsuit, it talks about the regulatory burdens. Let's see, Utah participates in Medicaid and must comply with the final rule. Compliance with the final rule will add new regulatory burdens and impose substantial costs on the state. What are some examples of the regulatory burdens and substantial costs that the state foresees as a result of the final rule? What is?
That's a brilliant question. I mean, that and to some degree, whoever asked that question really hit at the heart of the matter, because I think, and I wasn't part of the initial filing of the lawsuit, but I think one of the real concerns was with this piece of the new federal regulation, it would require accommodations here. I mean, as you mentioned, Section 504 obviously applies to anything where there is federal funding. and federal funds that come down and are taken advantage of by the states and those of us involved. The real question was, what do those accommodations look like, right? Under ADA and other laws, we need to make reasonable accommodations, right? And this is, I mean, there's a lot of case law on this. I actually taught as an adjunct at a university level, taught law for about 12 years, and I accommodated many a student who came in with a request for accommodations, and that's part of our culture. And I was happy to do it, and if it helped them, my job was to do that. I think the question though is, what do those accommodations look like? And we don't know. And I think other states aren't certain. And we don't have time to go through it now, but if you do look at the actual filing from last September, there's probably 15 or 20 pages where a lot of the states go by, it goes by state by state by state. I looked at Utah and it doesn't really say anything. I don't know why we didn't say anything. So I can't comment on that, but there's a lot of states where they basically said, look, the concern is, here's what an accommodation might look like. And it could be very costly, or it could, and if we don't do these costly accommodations, then we risk losing 504 funding for our kids. And so I think that's the real, I think that's the real issue at play. And so anyway, whoever asked that question, that's really kind of hitting at the heart of the matter.
Well, we had some wonderful questions and we've tried to cover most of them here. Um, what I think is important to remember is that, like you said earlier, it's people. People are behind all of these regulations and rules and enforcement. It's people. And sometimes legislators and people in charge uh, think it's about money and but it's really money that's meant to be spent on the people in the country. And so I appreciate you caring about the people and the stories because stories matter. So the last important question is, what can we do? What are we supposed to do? Are we just supposed to sit and wait with bated breath? I have a slide here and I'm like, okay, next steps for 504. I mean, ask Derek Brown to defend it. He's trying to defend it. Share why your story matters, why it's important to your family, educate others about it, because a lot of people don't understand what 504 covers, why it's important, and they don't realize that pretty much I think everyone in their lifetime is going to have Section 504 affect them because as we age, we all get a disability. If you don't have one already, you're going to get one. And so it affects all of us to some degree. And so I don't know what the next steps are. I prepared a slide and I honestly, what are the next steps that you suggest that we can do to aid you in the negotiation process so that or understand, okay, at this point we need to go stage a 25-day sit-in like they did in the 1970s. Like what do you think the next steps are for
Well,
us?
the next step really, I mean, just to be fully transparent, the next step is for the attorneys general to really take this bull by the horns, which we've done. And I think we can come up with some solutions. I mean, my hope is that people won't be too concerned. I think being educated and aware of 504 is absolutely critical. Please do that. Francesca, as you mentioned, I mean, this is going to impact every one of us possibly at some point. And the reality is there's almost no one out there for whom this is not impacted because everybody has someone in their life that benefits from 504. I mean, I would venture a guess that just about everyone out there does. And so, I mean, I can tell you that we are working really hard. We're working with other states. As you mentioned, really it's us being at the table and Utah keeping its place at the table. And I know that there's probably some frustration from people that really want me to just, end Utah's involvement in the lawsuit. But I'm not going to do that because I care too much. I'm going to sit there. We're going to work this thing through. And all I can say is we will keep you posted on what the updates are. But looking at your slide, I think those are great ideas. Be aware of what that is and be educated on the importance of 504. And it will continue to be, I think an updated law as the years pass on, and hopefully that we're able to identify that and identify how we can help those in need of it, and stay in touch, follow, I would say for the people on this call, follow what the Utah Food Allergy Network does, follow Nate Cripps and the Disability Law Center. I know Nate's up at the Capitol, literally working on these bills as we speak. And so there's a lot of moving pieces. And so be educated and stay in touch with us. And hopefully we will have, I think, positive news to report very, very shortly. But I really, and I don't want to overstate it, but I just don't think right now, I think that any threat is sort of past. I think we've got the right people at the table to give people comfort and ease. And Francesca, you mentioned you're not totally at ease, and I can totally understand and sympathize with that. You would probably not be at ease until the lawsuit is dismissed, and that's your job, is to worry, and so do that. It's good for people to be on edge, and that's my job as well as Attorney General, is to be vigilant and to watch this. And so my commitment is that I will do that, and I hope you do. I hope you do reach out.
Well,
And
true. I think knowledge is power. So I think educating yourself and others about it is important. Nate, I'm sorry I interrupted you.
no, and I know I've talked to Attorney General Brown about this earlier. I think certainly the status report they put out, I think being clear about what the intent is helpful. I think we appreciate that. I appreciate the conversations I've had with him and his office about the lawsuit, and the concerns we had and we brought to him from our community. And I appreciate those assurances. One thing, my hope is that there will be a quick resolution that sees the lawsuit, go away. I understand there are policy differences on the regulation and what is and is not appropriate and who gets to decide that. And those are all questions that they will work through. So my hope is we can get a swift resolution. I think for us, I will say he knows this. I told him it earlier today, that ultimately I think if we're going to proceed and it's going to take a long time, I do think an amended complaint is something that they should consider to pull out some of those the claims about unconstitutionality of Section 504. I understand that may require asking the court for permission, and there are some legal hoops to jump through on that end. But that's certainly something I think that should be considered. I understand, he is not the only Attorney General that gets to make that decision. There's other parties involved, but if this is going to drag out, I certainly think it's something that they should look at, and something we have encouraged, and that just want to pass that along. So.
And I might add, that's a great suggestion, and I will take that back, because I think a way that we probably could eliminate a lot of the concern as well. And can I just add, this is obviously an important issue, but there will be other issues that impact the community, and just please do reach out when those come, and inform us, keep us informed if there are things that we should be doing that we're not, or things that we're not aware of. Because as I mentioned, this entire issue, like I found out about it because a number of people reached out, they cared enough to reach out and say, hey, Derek, will you look into this issue? What is this? So, I appreciate that. And I don't want people to be unnecessarily fearful, because there's a lot of people here who carry heavy burdens, and there's a lot already going on. And so, I mean, just rest easy knowing that there are a lot of people who share the concerns and will continue to advocate.
Well, thank you so much. Thank you for your participation here. I am sharing some contact slides, and like he said, your story matters. And I think it's important to realize that your lived experience matters. No one understands it like you. And so sharing those stories of why it's important and what it means to you is super important. And so we're grateful for you and your commitment to transparency and the process of listening and going back to the negotiation table for us. We appreciate that. I'm thankful for Nate, for Krippus for showing up, and for helping us at the Disability Law Center. We're grateful for nonprofits, because all of us in the nonprofit world, we do a lot for for each other, and we're glad to collaborate. And thankful for our very kind and helpful ASL interpreter. Thank you so much for being here tonight, because we want to be inclusive of everyone. And Utah Parent Center was able to help us with that. And I am grateful to serve the Utah food allergy community. And once again, thank everybody for your stories. Keep sharing them, because the lawsuit isn't gone. However, we do have someone who's fighting for us, and we appreciate that. So thank you so much, and I hope everyone has a good night.
Thank you. I appreciate it,
Thank you.
everyone.